I know many of you have been very frustrated with these left-wing activist judges doing their best to impede President Trump's absolutely relentless dismantling of the administrative state. Since President Trump reclaimed the executive branch in January, more than 50 lawsuits have been filed to halt his America First efforts, with a number of activist judges ruling to restrain those efforts. But many don't realize that the Trump administration actually appears to have anticipated these efforts, and they are effectively outfoxing these judges at every turn. Case in point, you may have heard of the recent arrest of the pro-Hamas activist Mahmoud Khalil. Now, Khalil is a Syrian who's here in the United States on a green card and has been a pro-Hamas activist on the campus of Columbia University in New York. The Department of Homeland Security took him into custody with the intent to revoke his green card and deport him after he repeatedly expressed public support for Hamas terrorist activities and the destruction of Western civilization. Now, the justification for that is really, frankly, rather simple. Green cards are not citizenship. Your green card, for right or for wrong, your green card can be revoked. And bottom line, you don't get to espouse terrorist activity as a non-citizen, even if you have a green card. All right, so that's the argument. But then, true to form, a New York judge named Jesse Furman stepped in and blocked Khalil's deportation and ordered legal representation for both sides to appear before a New York court this week. Here is where things get very, very interesting. The petition that was filed on Khalil's behalf was, of course, filed in a New York court. This is what woke leftists have been doing in virtually all of these 50 cases against President Trump. You know this. They go to some left-wing activist judge in a blue state or a blue district to issue a ruling that tries to stop President Trump from carrying out his executive authority. So the same thing happened here. A petition for Khalil's release was filed in a New York court, and the judge, true to form, complied. Here's the problem, however, for this judge. Homeland Security immediately moved Khalil to an ICE detention center in Louisiana. Why is that important? Because while Judge Furman issued his order based on Khalil's New York petition, apparently the law requires that the petition be filed in the federal court district the subject is being held in. So if Khalil isn't in New York anymore, then this judge has absolutely no jurisdiction whatsoever over the case. And given that Khalil is now in a red state, Louisiana, rather than a blue state, good luck finding an activist judge to release him. So the Trump administration appears to have outfoxed the left-wing judiciary. They're a step ahead of these liberal judges, at least when it comes to this case. But actually, as it turns out, what they did with Khalil, is nothing. Wait until you see how Trump is actually outfoxing the entire activist judicial system and has planned out how to end judicial activism against the executive branch once and for all. But first, gang, I want everyone to know that if you're finding yourself in the painful position of owing back taxes, we got some patriots here to help you out. As I'm sure you all know, the IRS has been doing its darndest to make sure everyone pays up. They've hired thousands of new agents and sent over 5 million pay-up letters in 2024 alone. But if you're dealing with this mess, I want to connect you with a real, tangible solution. Don't give up your rights, and certainly don't deal with the IRS alone. They're not your friend. Let Tax Network USA, a trusted tax relief firm, save you the time and money you deserve to keep. They've saved Americans, get this, over $1 billion. That's billion with a B in back taxes. And they've got the skills needed to secure you the best possible deal. From a few $1,000s to 10 million, business to personal taxes, let Tax Network USA restore your good standing so you can strengthen your financial foundation. Because when your situation is secure, you become the pillar of strength our nation needs. Click on the link below for a private free consultation or visit them at tnusa.com/Turley. Now, you may not know this, but President Trump is actually going for it all when it comes to these activist judges. And when I say all, I mean all. The Justice Department is aiming straight at the heart when it comes to judicial activism against the executive branch in our nation. Pam Bondi's Justice Department is formally urging the Supreme Court to overrule the decision that's allowing these judicial activists to make their silly rulings in the first place. It all goes back to a 1935 Supreme Court ruling known as Humphrey's Executor versus the United States. And if you look it up, you'll find that the summary of the ruling, it basically says that presidents can only fire independent agency commissioners for serious reasons. In other words, the case established that the president does not have unlimited power to remove executive officials. So specifically, the Humphrey's Executor decision, in effect, restrained the president's powers as provided by Section 1 of Article 2 in the Constitution, which provides that, quote, the executive power shall be vested in a president of the United States of America. And then Section 2, among other things, provides that the president, quote, shall have power by and with the advice and consent of the Senate to appoint all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law, but the Congress may by law vest the appointment of such inferior officers as they think proper in the president alone, in the courts of law, or in the heads of the departments. Now, the key here is that while Article 2 talks about what the president can do in terms of hiring, it says nothing about firing. And so the general precedent before 1935 was that the president had ultimate authority to fire whoever he wanted under the executive branch. I mean, it's just assumed if there's no delineated authority to fire, well, you can only fire this or that. No, then he could fire anybody. But then came the Humphrey Executor case, and this involved President Franklin Roosevelt firing William Humphrey from his position on the Federal Trade Commission before the expiration of Humphrey's 6-year term, and in violation of the Federal Trade Commission Act, which provided for the removal of an FTC member only under certain specific circumstances, such as inefficiency or neglect of duty or malfeasance in office. Humphrey actually ended up dying before the Supreme Court issued its decision in 1935, which then resulted in his executor of his estate continuing the litigation and seeking money damages for lost wages. Now, the decision was interesting because on the one hand, it drew from an earlier Supreme Court decision called the Myers decision that basically said that Article 2 does indeed give the president unrestricted power to fire, remove executive officers. The Humphrey Executor decision affirmed that. But on the other hand, the Humphrey Executor decision made an exception for the FTC, for the Federal Trade Commission, stating that they had some overlap with the judicial and legislative branches, and therefore the president's hands were tied as to whether he could fire an FTC officer. So Humphrey's Executor has been the linchpin ever since for all of these lawsuits alleging that the president has limited power in terms of who he can fire when it comes to executive employees. However, and this is huge in terms of what our current Supreme Court is going to consider in their ruling with regard to these lawsuits later on this summer. The Humphrey's Executor decision got something seriously and factually wrong, and it's been pointed out in other lawsuits and even other Supreme Court decisions. They wrongly designated the FTC, the Federal Trade Commission, as exercising, quote, no part of the executive power. In other words, the Humphrey ruling in claiming that the FTC exercised no part of the executive power categorized the FTC wrongly. They understood the FTC wrongly. And that factual error alone would justify the Supreme Court overruling this decision. And in fact, Roe v. weighing it, overturning it. That is what the Supreme Court observers today are keeping their eyes on coming this summer's ruling, which should be in June or July. This ambiguity that the president has unlimited power to fire executive officers, but with some exceptions, some limitations as per the Humphrey decision, is precisely why we're seeing this back and forth, these ping-pong decisions coming from the courts. One saying Trump has no authority to fire, he has no authority to stop USAID fund payments, and so on. Then the other overrules him, says, absolutely not, go right ahead. You have all the authority in the world as the chief executive. So the question really comes down to, will the Supreme Court further clarify what restraints the president has in terms of who he can fire in the executive branch, or will it just overturn entirely the ruling that delineated those restraints in the first place? Pam Bondi's Justice Department is going for it all. They have formally filed a petition for the Supreme Court to overrule this decision, especially given its glaring factual error as the basis for its decision and what many believe to be Humphrey's blatant violation of the separation of powers. The president alone, elected by the people, does indeed have ultimate authority over all the operations of the executive branch on behalf of the people. And Humphrey is unduly impeded on that authority. That's exactly what Justice Sam Alito was so upset about the other week, right? In Roberts and Barrett's decision to allow these cases against Trump's executive authority to continue to play out in the appellate process. It was a procedural decision, not a merits decision. But Alito was like, why the heck are we even thinking of allowing a New York district judge to have the right to stop the president of the United States, elected by the people, from exercising his constitutional authority? This is precisely the kind of absurdity that the Humphrey decision allows for. So that's what we'll be keeping a very close eye on in the coming months, the fate of the Humphrey decision. It looks like 4 justices are ready to absolutely destroy it, toss it on its ear, as it were. We'll see what happens with Barrett and Roberts. If that decision is indeed overturned, President Trump gets everything. Everything he wants. Not a single decision from any of these activist judges will even remotely stand. All of these lawsuits will dissipate into dust. And we will finally place executive power back into the hands of the people, where it belongs. By the way, click on the link in the description below to get all these articles and tweets I reference throughout my videos emailed to you each and every day. You're going to love it. We want you to have the best resources out there to convince your family and your friends of this new MAGA super age that's rising here.